Please be seated. Good morning. Welcome to the First District Court of Appeals. We have two cases on the docket this morning, and we'll take them in the order as listed on the schedule. Our first case is White versus Discovery Communication et al. That is case number 221321. Counsel, are you ready to proceed?
Yes, Your Honor. May it please the court. I'm Joe Little from Gainesville. I, along with lead counsel Charles Barfield, represent Appellate White in this matter. I request 5 minutes for rebuttal by Mr. Barfield.
5 minutes. So noted. Thank you, Professor. Go ahead.
Appellate White is a poor, uneducated black man who lives peaceably in Franklin County, Florida. He's never murdered anyone and never been in the New York state. Appellee's Microsoft is a billion-dollar global company with many functions. Among them is selling and streaming television programs from its platforms to purchasers and subscribers throughout the United States, including Florida and the world. This is a direct sales activity that is not regulated by the Communications Decency Act, that I'll refer to as the DCA. Microsoft directly streamed and published the defamatory television depiction of Appellate White as a serial killer in an episode known as, quote, "I invited him in." Microsoft directly published this defamation in Florida, nationwide, and globally. Microsoft also published the defamatory depiction through its Bing search engine in a manner that does not invoke CDA immunity. Appellate adduced positive evidence of Microsoft's direct TV publications that are not immunized by CDA, and the trial court completely ignored it to grant Microsoft's motion for summary judgment on the grounds of CDA immunity.
Well, can I ask you about that? We've got the affidavit, which is questioned from Mr. White because it's not sworn. But besides the affidavit, where is there record evidence showing that Microsoft published the allegedly defamatory program?
Your Honor, we have several matters of evidence that I will refer to you. On the record in page 313 is a letter from Microsoft to Discovery, LLC, which states, quote, "Microsoft began undertaking efforts to prevent viewers from accessing the episode titled, quote, 'I invited him in,' unquote, from season 4 of the Evil Lives Here series through any of Microsoft's platforms. Microsoft's request that Discovery remove the episode from availability for online digital streaming and/or notify all its licensees or affiliates that the episode be removed."
So it's your contention that if you host a website, you're like Microsoft, you host a website and you take some information in from a third party, if you pull that information off of your website, that makes you a publisher of it?
No, we're not saying they pulled it off his website. We're saying they streamed it into Florida, which is different from pulling it off a website.
Well, and that raises an interesting question, where's the record evidence besides Mr. White's affidavit that it was streamed into Florida?
It was streamed, Your Honor, Microsoft is a global company. Let me read you some other evidence here. Mr. White requested Microsoft to admit this. Microsoft offered for sale the episode "I Invited Him in the series Evil Lives Here in the United States or globally. And Microsoft responded that the episode at issue was available to be downloaded from the link that Mr. White had provided him.
But to publish it, doesn't somebody in Florida have to actually receive it?
Yes.
The fact that it's available out there is not enough. There's got to be record evidence that somebody got it, right? And where's that record evidence?
We have evidence in the record of these cases that the episode was received and seen by viewers in Florida, Your Honor. Microsoft, we don't know how many viewers they have in Florida, but presumably thousands. And we know it was streamed for months, years.
But under my understanding, under Doe v. AOL, Florida requires for it to come into Florida, for there be the defamation to occur in Florida, somebody actually has to take hold of it in Florida,
Yes.
right? So is there any other evidence besides Mr. White's affidavit that occurred?
In this case, Your Honor, we may not have that evidence in the record, but in the other cases, we certainly do have that evidence in the record. Appellate White requested Microsoft to admit this. The episode I invited him in the series Evil Lives Here in the United States or globally was sold by Microsoft from its website or websites, included the image of Plaintiff White. And Microsoft responded. Microsoft admits that the image of Plaintiff White is displayed briefly during the episode described in the request. In sum, Your Honor, the evidence is that Microsoft was streaming this program throughout the United States, and that includes Florida, and globally, for a long period of time. Microsoft took to tell us that we're taking it all down. We're not streaming it anymore. And Your Honor, I don't know why that's not sufficient for a jury to determine that, in fact, the matter was viewed and seen and streamed into Florida.
Can I ask you, before we burn through all your time, on, I think it was in the reply brief, there was mention of this Gonzalez versus Google case in the U.S. Supreme Court dealing with 230. What bearing does that have on the summary judgment here?
Your Honor, in our opinion, it has no bearing on the direct publishing theory, which is not covered. Direct streaming by television into the state is not covered by CDA. It has to be posting something on a website that is covered. Now, on that point, that's our second argument is that Microsoft used its Bing search engine to search out images of Mr. White, depicting him as a serial killer, and delivered them to its users. Now, Microsoft says that's covered by CDA, and that was the basis that the court, I think, may have. We don't know exactly why the court did what the court did. But that's the very issue that's at issue in the Gonzalez case. There, the Supreme Court of Florida, and that case was heard in October by the Supreme Court of Florida, and it has not been decided yet. At least I checked yesterday, and it had not yet been decided. But the Supreme Court is going to decide whether that, I think, will decide whether or not that activity, and our second theory, is in fact immunized by CDA. We respectfully argue that it should not be immunized because this is not a case where Microsoft simply set up a website and said, anybody who wants to post something on our website, have at it. That's a case like in the Giordano case and the AOL case in Florida that the courts have held is immunized by CDA because it's somebody else making use of the internet put up by Microsoft.
In either event, whether it's the streaming argument or the search engine argument, in order under 230 to be considered a publisher, don't they have to participate in the creation or the development of the content?
And not, Your Honor, if we're just streaming television, such as comes over Cox Cable or through your telephone lines. No, Your Honor, that's not covered by CDA because that's not the internet. The internet is something different from the direct streaming of a product such as you've described. So the direct screening is not a CDA covered matter. It's the internet where somebody puts up a website, such as the Giordano case, and somebody else comes and puts something on that website that is defamatory. Your Honors, this case has to be reversed on procedural grounds. The court made a conclusory statement that there's no dispute of a material fact. The Supreme Court said that is not sufficient. The Supreme Court mandated trial courts to give a basis and reason for their arguments, and the court didn't do it. So the court ought to reverse on that grounds alone, and if they require the circuit court to examine the evidence and make a decision on the evidence.
And we're into your rebuttal time, but we'll give you a little more time on this because I want to ask you about that second point. The new rule 1.510A says the court shall state on the record the reasons for granting or denying the motion. At the hearing and then also in her written order, Judge Dempsey said there's no dispute of material fact such that the case can go forward, so I'm granting the motion. Why is that not enough under the revised rule?
Well, the Supreme Court has said specifically this. To comply with this requirement, it will not be enough for the court to make a conclusory statement that there is or not a genuine dispute as to material fact. The court must state the reasons for its decision with enough specificity to provide useful guidance to the parties and, if necessary, for allowing appellate review, unquote. That's in the decision which the court adopted. The rule, and it's been quoted by the 3rd District and the 4th District, reversing decisions such as the one that this court has before it. In other words, the court must say, I have examined the evidence, and because of this examination, I find that the complainant or the case is defective and must be dismissed. The court didn't do that, Your Honor. Thank you.
We'll reserve the rest of your time for rebuttal, and we'll give you 2 minutes more for your rebuttal, and same for the appellees during their presentation.
Good morning, and may it please the court, Catherine Clemente on behalf of Microsoft. The trial court correctly granted summary judgment under Section 230 of the Communications Decency Act because Microsoft was not the information content provider for the episode or web pages for which plaintiff seeks to hold Microsoft liable. Section 230C1 broadly mandates that, quote, no provider of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. On appeal, plaintiff's submissions do not address the Section 230 prongs individually, but it is apparent that plaintiff does not dispute 2 of the 3. First, that Microsoft is an interactive computer service, and second, that plaintiff is seeking to hold Microsoft liable as a publisher of third-party content. As we understand the initial brief then, the sole question on this appeal, as it relates to the summary judgment order, is whether Microsoft materially contributed to the alleged illegality of the episode or web pages. The record demonstrates that it did not. There are two buckets of content, as my adversary noted, for which plaintiff seeks to hold Microsoft liable. First are the 8 web pages that we understand plaintiff may have accessed following a Bing search. And the second is the episode itself, allegedly accessed through online streaming on Microsoft's platforms. First, as to plaintiff's web pages or search engine theory of liability, search engines are neutral tools. They do not create content, but rather serve content to users upon request. Plaintiff seemingly understands this. He conceded at his deposition that he does not know Microsoft to have authored any of the web pages in the record at 212 through 213, but regardless, the web pages themselves demonstrate that they were authored by various third parties, not Microsoft. In his initial brief, plaintiff only raises error with one of the 8 web pages, the US Serial Killer Addresses website, which was authored by an anonymous poster called, quote, the Feral Blue Chicken. That's the record at 194 through 195, not Microsoft. Plaintiff has waived any argument as to the other 7 web pages. Second, as to plaintiff's streaming theory of liability, as we note in our brief, we believe that this argument has been waived as plaintiff failed to plead it or raise it in his summary judgment response, which is in the record at 382 through 397, as required by Rule 1.510C and the Lloyd S. Measles case. Plaintiff only argued for the first time at the summary judgment hearing that Microsoft is liable because it allegedly sold the episode through online streaming access that is insufficient for preservation under the amended rule. Either way, the trial court was only required to consider the cited record materials in entering summary judgment under Rule 1.510C, and plaintiff's summary judgment response cited nothing. But even if this court determines that plaintiff preserved this argument, it is undisputed that Red Marble Media produced the episode and that Discovery broadcast it. Discovery admitted that Red Marble produced the episode. That's in the record at 149. Plaintiff admitted in his complaint and his deposition, the complaint at record 27, that Red Marble and or Discovery is the information content provider responsible for the episode. In his deposition, that's 212 through 213 of the record. Plaintiff also testified that he did not understand Microsoft to have had any hand in the production of the episode, same site. Plaintiff failed to allege in the complaint or adduce any evidence to show that Microsoft was involved in any way in the creation or development of the episode. The fundamental legal question we submit is whether Microsoft provided the specific information for which plaintiff seeks to hold Microsoft liable. Here, the choice to include plaintiff's photo at the end of the episode. Plaintiff's streaming argument does not provide a basis for reversal, as Microsoft did not provide the content of the episode.
Can I ask you, the In re Facebook case from Texas was mentioned, and I thought that was an interesting case. Are you aware of any Florida courts going as far as the Texas Supreme Court did there in immunizing under 230 Facebook?
We are not aware of a Florida court that went that far, but Your Honor mentioned the Doe v. America Online case earlier. And what I think bears mentioning here under plaintiff's sort of evolving theory of liability is that in that case, the Florida Supreme Court spent a lot of time discussing the history of the statute and found very persuasive some of the case law leading up to it. So one of the cases that the Florida Supreme Court discussed at length is a case called Cubby Inc. v. CompuServe. It was an SDNY case from 1991, so it predates the CDA. And this is quoting from the Florida Supreme Court's opinion, 783 Southern 2nd at 1014. In that case, quote, the federal district court held in a defamation action that CompuServe, a service provider that offered its subscribers access to an electronic library of news publications was a mere distributor of information and could not be held liable for libelous statements made in those news publications. Without a showing of actual knowledge, it went into the defamation standard again because we didn't have CDA immunity yet. But Congress, in enacting the statute, pointed to this case as a good result, as opposed to some of the cases that Congress explicitly overturned with the enactment of the CDA. So we have an idea from Doe v. America Online that simply providing access to third-party content through a library like this, much like streaming, is immunized in this state.
For the purposes of, so you have kind of two prongs under 230. You have the content creation or development piece, but then you also have to be an interactive computer service, right? And so certainly Microsoft has aspects of its business that would be fairly considered an interactive computer service, but there may be aspects of its business that wouldn't. So how should we think about this, particularly with regard to the streaming aspect of it? Is providing a streaming service, is that really an interactive computer service? Is that really a place where third parties can come and post information and third-party content in the way that maybe the interactive service, computer service provisions contemplate?
We contend that it does. An interactive computer service is, and I'm reading from my notes here, it's something that enables computer access by multiple users to a computer server. And I believe it's either the Roommates case or the Jones case from the Sixth Circuit that explains that this is most commonly a website. And so a website is the medium through which plaintiff alleges that he accessed the streaming content. So regardless of the fact that it is a streaming video, it is still being accessed through an online platform. And so I have to respectfully disagree with my adversary that this is akin to television broadcasting, because it's not. It's a different medium. If this were broadcast on television through the traditional medium, the CDA wouldn't apply.
So the distinction is just, so appellant talks about, the cable coming into the house. It comes in a traditional cable format. And there's content that you can get that way, and then you can get the very same content via a streaming service, maybe a parallel streaming service via the internet, maybe an internet that runs over the same cable even. But that's the distinction that you're pointing to? It's how it gets there?
Well, the distinction I'm pointing to, that is sort of the distinction that I'm pointing to, but it's also sort of the decision that Congress made here in providing immunity for online service providers as opposed to traditional print media or traditional television broadcast. This is sort of the bargain that was struck in the 90s, with this broad immunity, not understanding that they couldn't necessarily foresee how the internet would develop. But so long as it is being accessed through an online service provider, traditional publishing functions are immune so long as the publisher has not contributed to the creation or development of the content. And to that point, the case law is clear that where a defendant's role is strictly one of output control, its action constitutes the very essence of publishing and is immune. That's the Bennett case from the DC Circuit. There is no creation or development where the website does, quote, absolutely nothing to enhance the defamatory sting of the message, to encourage defamation, or to make defamation easier. That's the Roommates case from the Ninth Circuit. And then finally, a website operator is not, quote, responsible for the development of content created by a third party merely by displaying or allowing access to it. That's the Jones case from the Sixth Circuit.
How does Microsoft's decision to pull the episode from platforms relate to its liability then?
So I would submit that that is a traditional publishing function. It is an editorial function that is immunized by the statute. I believe that the initial brief sort of collapses two of the Section 230 prongs, such that publishing and information content providing are melded together, but they're different. And so long as Microsoft did not provide the underlying content, materially contributed to its alleged illegality, its decision to place or remove that content is immune. It's sort of the essence of Section 230 immunity.
Can I ask you a question I asked the appellant, the Gonzalez versus Google case that's up at the Supreme Court? I have not read the numerous briefs and probably amici briefs on that. Does that have any bearing on what we're doing here today?
I don't believe so. It's a very narrow question presented in that case, if I may. I have it right here. Does Section 230C1 immunize interactive computer services when they make targeted recommendations of information provided by another information content provider, or only limit the liability of interactive computer services when they engage in traditional editorial functions, such as deciding whether to display or withdraw with regard to such information? The targeted recommendations of information in that case, from what I recall, has to do with Google's pairing of content or suggesting content of dealing with ISIS's YouTube channel, including advertisements. So it's quite a narrow case. It also went up on a motion to dismiss. So we submit that the universe of case law and the statute itself is enough for this court to affirm.
Thank you. Before we get through all your time, can I ask you about the second argument that appellant makes on the order from Judge Dempsey allegedly being insufficient under the revised 1.510? How do you respond to that?
My response to that is the trial court did not simply say there is no genuine issue of material fact, such that Microsoft is entitled to judgment as a matter of law. The trial court said, and here it is, final order 373 through 374, the court ruled plaintiff's claim against Microsoft, I'm quoting from 374 now, plaintiff's claim against Microsoft is barred by Section 230 of the Communications Decency Act, and then cited the statute. So the reason was provided there, and there's nothing in the amended rule that says that the trial court needed to have made detailed findings of fact or provided multiple reasons. It just needed to state its reason on the record, to provide useful guidance to the parties, and provide for appellate review. And we know what we're here on today. We are here on Section 230 immunity. We'll rely on our brief for the remainder of our time.
Thank you, counsel.
Thank you.
May it please the court. Charles Barfield here, co-counsel with Mr. Little, and we represent Nathaniel White in this matter. Judges, I respectfully say that there's been, I don't know, either a misstatement, but there's some clear, I think, inaccurate statements regarding 230 as applied to this case. This case here, the appellant is arguing it is Microsoft is a direct publisher, which excludes 230 from consideration. And the reason being, when I say direct publisher, it is well established in the record, and I will quote the record on pages 276 and 277, where Microsoft says that it is undertaking efforts to remove the episode from its platforms. And this is a letter from, to me, from Microsoft co-counsel who's here, Amy Hausinger. Also on the record on page 314, in response to one of our limited and scant discovery offers or omissions, quote, Microsoft, we asked a question, and the issue is Microsoft offer for sale the episode. I invited him in the series Evil Lives Here, in the United States or globally. Microsoft responded, quote, that the episode at issue was able to be downloaded from the link provided, record 314. Now, what this means, Your Honor, is that this is linear distribution, meaning television. So you can stream or digital stream this program for a profit with Microsoft contracts with Disney, Discovery for a fee. They're not doing this because they like each other. This is a concerted action between two business and entities. So therefore, this is not an internet situation per se. This is linear distribution from TV. You can stream things from your TV. Now, Microsoft has not admitted that, and they haven't given us all the discovery that we've been asking for. But the bottom line is that they use the word platforms in the letter to me, and as well as what Mr. Little referred to earlier, the letter to Mr. Webster. So the issue here is who has exclusive control. You're talking about creating the defamatory product. Well, we say, the appellant says that Microsoft, in a contractual agreement with Discovery, they have mutual financial gain, mutual interest via contract. And because of that contract, it's that issue.
Do we have any record evidence of that?
Well, we have, in a related case, Discovery has initially didn't provide a contract in the record. However, when it was convenient for Discovery in their motion for summary judgment, they did apply that contract to in the record. We, as the appellants, asked this court to then make that a part of this record because this court could have taken judicial notice, but it said no. And
perhaps the reason why we said no was it was not before the trial court at the time of the summary judgment hearing, right?
no, it was. It was before the trial court. In fact, Microsoft did initially was going to give us that contract. And 3 months, they reneged on it. And this was in the record way before the trial court had that in her purview at the time. And then Discovery, through Mr. Webster, intervened and literally told Ms. Hollinger and Microsoft lawyers, no, do not give the plaintiff or the appellant access to that contract because it's so-called trade secret. However, after litigation, then Mr. Webster, on his own initiative, filed it in the trial court record, that contract. So we believe that the contract itself makes Microsoft and Discovery bound together. You can access this streaming on your television, which is traditional publication, which 230 does not deal with linear distribution. Okay, 230 is designed for internet, and they keep using this word internet, but you can actually stream from your TV, from your phone, and we don't know how many other areas that Microsoft has said because they did not comply with a fundamental discovery. And I think it offends the notion of fundamental fairness when you have a billion-dollar global company that don't even fully, in good faith, participate in discovery. And so
Thank you,
many of the
Counsel.
questions we have.
Counsel, you're a minute over your time. I'll let you sum up if you want to conclude briefly.
I'm simply saying, judges, that it's very difficult or concerning to me that if the discovery request that we have consistently tried to litigate in this case with motions to compel, and yet Microsoft has failed to comply with those discovery requests. So it's easy for them to say, well, we don't have this, we don't have that. The point of any civil trial is to get information. If we can't get all the information and they have the information, it's very easy to say, well, the plaintiff or the appellant can't prove this, this, or that.
Thank you, Counsel. Your time has expired.
Thank you, Your Honor.
Thank you both for your argument. That case is submitted, and we'll take a minute to reset the